May it please your lordship.
Yes.
Your lordship, with due consent from the other side, I'd like to mention item number 18.
Item
18. The partner matter. In this matter, I am being led by Mr. Rohan Shah, senior advocate from Mumbai. So today he is somewhat indisposed. So may I plead the matter may be taken up on December 12th?
we don't know. Partner matter, it will come when this bench is available in some time in December. Or if you want, we release it from partner, whatever you want.
Your lordship may keep it in partner. Interim order may continue.
We see it will let it be listed in December. We adjourned on 18th, item 18. Passed over for the day. We see.
Interim order may continue.
Interim order will continue.
Highly obliged.
May I please, your lord? My lord, I beg to mention for listing of a pending contempt case, my lord.
Why?
My lord, small amount, my lord, contractual amount was directed to a credit card.
Monday?
May I please, your lordship? I beg to mention for listing of a contempt petition civil in order for
Monday.
May I please, your lordship? Lordship, I pray for listing a contempt petition.
Monday.
I'm so obliged.
May I please, your lordship, with the consent of the other side, I beg to mention item number 20, lordship.
20.
2020.
For the other side.
Yes, your lordship.
Marshal,
We are repairing.
Respondent number 5, Marshal.
No objection.
No objection, your lordship.
Maybe adjourned.
Adjourn to be listed. When do you want it?
In the next week, lordship, because the conducting counsel, Mr. A. Bhattacharya, has been suffering from fever, lordship.
Your lordship, after 15 December, your lordship.
Why don't you have it in January instead?
Yeah,
In
yes,
December?
yes, your lordship.
What do you mean, yes?
No, lordship, actually.
We are having it next week. It's a request made by the council for the petitioner. If you have problem,
Of second week of December, your lordship.
no, next week.
Okay, obliged, your lordship.
Much obliged.
Obliged.
May I please, lordship? I beg to mention withdraw a petition.
Withdrawal tomorrow.
Deeply obliged.
May it please your lordship, I beg to mention one writ petition. Kindly the water may be listed on 20.
You want it on 20?
Yes.
No. You can have it on a motion day. 19. Sorry, 26. 26. Yeah.
Another writ petition is there.
For
in
orders,
both the matters-
motions, admissions, what?
admission in admission column.
Admission. 26.
Meet pleases your lordship. Lordship, I beg to mention for listing of a writ petition. Matter may come up on 27 November
So date will take. Tell us what the matter is.
for admission, your lordship.
Admission. And it will be on 27.
Deeply obliged.
Well, same issue is already under consideration in the court number 17.
Sorry?
Same issue, my lord,
Yes.
of the same petitioners hearing, parties hearing, is already under consideration in court number 17. There also, my lord, 3 or 4 cases are listed, my lord, of the same impugn order. So I say, my lord, already, my lord, before deliberation has been held, my lord, in court 17.
Very well.
Whatever
it
is the outcome, will cover this case today itself.
It is submitted that. No, you want this matter to be listed
Adjourn.
together? Or you want this?
Or adjourn, or my lord, the clerk will-
submitted
because
that-
today, if it is already decided, then in that case, it will cover.
It is submitted that similar issues are being decided or heard and likely to be decided by a coordinate night. It is
Maybe adjourn for Saturday.
submitted that the matters be referred to next week.
Lordship.
Joint prayer. It will come. Yeah.
Okay.
One second.
May it please your lordship.
Yes.
My lord, as far as the accusation part is concerned, perhaps now it has become fait accompli, you know. We'll have to face it because once under 3D2, that notification is issued, then the land vests in the government. So that is happened. The petitioner is basically, he is a dealer of Tata Motor. Now, is it possible to shift within 3 days, Miller? Now an order has been issued that you shift within 3 days. That order basically which we have challenged as well as the award. In the earlier round of litigation, our prayer was that they should make an assessment and pay according to the Act of 2013. Now impugn order is at page 188. Miller. Now, in fact, we have made alternative arrangement, page 188. With reference to the subject cited above and in public interest, I am to request you to vacate your land along with structures falling within the alignment of the proposed Silchar Vairengte 4-lane within 3 days. Kindly see, my lord, I was a dealer of Tata Motors. Now already we have started construction and all, my lord, which we have given. We need some reasonable time, my lord. Nothing else. Lordship will invoke your
When-
lordship's
when-
extraordinary jurisdiction.
When was this issued?
It was issued on, my lord, 12/11. 12.
Yeah.
12/11.
Yes.
Lordship may kindly complete the order that you have been given sufficient time to shift your business establishment, but as informed by LR staff, there is no shifting from the acquired site till date.
When, how much time do you require?
Well, ideally, we require about. Well, our client's instruction is within 3 months we can shift. 3
Your
months will be.
3 months is,
Let it be 2 months, my lord.
2 months.
2 months, my lord.
we can give you, we can extend you for another 15 days.
Lord,
Let it be 2 months.
no, Lord.
So because
No,
straight
my
away
lord,
we can't
no,
say.
what I'm telling, Lord,
What-
definitely, my lord, it's a national project, therefore, we are not coming in the way. Only thing is, my lord, that portion can be wait. It happens, my lord. Sometimes some land acquisition proceeding is there, sometimes there is no shifting of poles by the APDCL, it happens.
So
My
if
lord,
they- if
2
they-
months will go, my lord.
If they agree, we have no difficulty with that. All we want to know is because this notice says sufficient time has already
No, my
been
lord,
done.
what has happened, there is a litigation pending, my lord.
Right.
Now, only the award has been passed only recently, my lord.
When was the award passed?
Award, my lord, I think one. Huh?
Impugn letter.
Huh?
Impugn letter.
In the letter itself, now it has been to inform me, Lord. As first subpara, as per approved 3G award list, your value of land and Jirat is well.
No,
This is the first time we got to know, Mila. If we are dissatisfied with this, my lord, we have got our remedies, my lord. We'll go for reference and all. My lord, 2
Yes.
months, 2 months will go.
2 months is more, it will be more, Lordship. 15 days, to 30 days.
You do one thing, you make an assessment and come back and give us a report.
Lordship,
How much time it would require?
Lordship,
Do that. Until then, you
Yes.
Lordship,
say this,
Allah.
we direct that no steps be taken in pursuance of this
Lordship.
order. All right? You are representing whom? PWD.
No, they are NHIDCL.
NHIDCL.
NHI.
NHIDCL. NHIDCL? NHIDCL. No, why? ADC, I'm a
You are representing whom?
DC, Lordship.
East. So it is the NHIDCL who has to tell us
Yes, yes.
who is for NHIDCL.
It will happen.
Normally, Mr. C. Borua appears, my lord.
Can you request the council?
His name is also reflected in the cause list.
He is not here.
Not yet.
Assessment is made by Kalla.
Can you
My lord,
request?
let the matter be called after 2 weeks. Status quo as on today be maintained. Lordship will take a call on that. I will inform them. We have served copy. Their names are also shown.
We can call up the matter after some time.
Right.
If possible, you request him to
But
be
they are
present, then
all-
otherwise we can close this matter also in his presence.
Actually, it can be closed, my lord, by
Right, but
giving
we
us
need
some
to
time.
present
Yes,
the
yes.
Council.
Basically. All right.
We'll call it up after a while.
My lord,
You inform Mr. Borua, whoever appears
Lordship.
for. Yes, sir, copies on Mr. C. Borua. Yes, after some time.
That the IA has been filed by one of the respondents, my lord, seeking modification of the order. But they have been trying. Today is also they are absent.
What is this order? Which order you are seeking type?
Sorry, my lord.
Which order you are seeking vacate?
My lord, they have filed the application.
They filed the I. You are for the writ petition.
I am for the application.
Yes.
My lord, they have filed the writ petition challenging the proceeding of mutation pending in the assistant settlement officer, your lordship. Subsequently, mutation was granted. Thereafter, they have filed again another writ petition challenging the mutation order. My humble submission before your lordship. My lord, there is provision, statutory provision for appeal against the order of assistant settlement officer. They can prefer appeal.
Which
before the-
order you want modification? Which order?
Yes, your lordship. Page 11, your lordship.
Page
11.
left. Yes.
Operating part 14, your lordship.
So you read the whole order.
No.
Second paragraph onward.
The case of the petitioners in brief is that he had purchased proprietary right in respect of 1 bigha 0 katha 10 lesser land in his possession out of 4 bigha 0 katha 8 lesser covered by Dag number Sancho, Patta number Sancho of village Alamganj part 7, Moza and Circle Dhuburi, which cell deed number Sancho dated Sancho. The name of the petitioners was mutated in the revenue records along with the patta holders of the said land. Thereafter, the petitioners had applied for mutation and accordingly, the portion was allowed by order dated Sancho. And a separate Dag number 340, patta number 45 was created in respect of the said land. Thereafter, the private respondents had applied for cancellation of the mutation and in respect of the state application, a case being so was registered before the circle officer, Gauripur Revenue Circle, wherein the petitioners filed their objection as well as written argument. The petitioner is aggrieved by the report of Lord Mandal to the circle officer, Gauripur Revenue Circle, indicating that an order can be passed for correction of the land records by inserting the name of the objector, that is private respondent. Issue notice returnable forthwith. Requisite extra copies of the writ petition be served. The petitioner shall take steps in view of the projection made in this writ petition, which is supported by entry made in the Chitha Annexure 6. That is separate Dag was created pursuant to order passed in partition case number so. The circle officer Gauripur Revenue Circle, while determining the matter in case number so shall first determine whether he has the jurisdiction to cancel the order of mutation under the provision of Assam Land and Revenue Regulation 1886. Thereafter, he will fix another date for passing final order in the matter. As an interim measure, the court is inclined to provide that whatever order is passed by the circle officer, Gauripur Revenue Circle shall not implement it till 26/7/23. Based on science, the petitioner shall produce a certified copy of this order before the circle officer, Gauripur Revenue Circle, to bring this order.
What is the status of the petition? It's still pending.
My lord,
Petition is pending.
in this assistant settlement officer, that is disposed of by
No, the writ petition is pending.
my lord.
Yes. So how are you affected by this order? It was still returnable date, subsequently extended.
My lord. So they have
Writ petition was filed by you.
Yes.
challenging the report of Lord Mandal, your lord.
That, as a matter of fact, when the matter
Yes.
came on 17th of September last this year, the Honorable Court was of the opinion that an affidavit from the side of the Revenue Department is necessary because of the fact that it goes to the root of the matter whether he has jurisdiction or not to
Decide.
undertake the kind of exercise. That affidavit is yet to come in this particular writ petition.
Who's for the government? Revenue Department? See, instead of deciding on this, how are you affected by the interim order?
17 times.
Ultimately, my lord, proceeding of the cancellation of
Because
interest.
he's questioning the jurisdiction. You're questioning the
Ye-
jurisdiction.
Yes.
To my understanding, my lord, writ petition is not maintainable. So for the provision of Assam Land and Regulation Act. There is a statutory provision for appeal law against the order of settlement officer.
Oh, that's right. But if he's
Right.
questioning the jurisdiction itself, why should we invite an order from an authority who does not have jurisdiction? You have to satisfy that he has the jurisdiction.
And another aspect of the matter, my lord, despite there being a specific order from this honorable court, they have simply brushed aside this order, the effect thereof, and they have passed a subsequent order, which is under challenge in the subsequent writ petition. So therefore, considering the entire aspects of the matter, my lord, the honorable court said that the revenue department should file an affidavit highlighting the point of jurisdiction, whether or not the circle officer can act in the manner that he has done now.
Where is the order of the circle of the report or order?
Subsequently. Well, the order passed by the circle officer is in the subsequent writ petition 5527. That is at page 82. Page 82.
Hmm.
That's clear. 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 Okay. Okay. 282. Page 282. Okay. 55.
Why are you questioning the jurisdiction here?
Well, of the section 41 is the provision under which Miller the records can be corrected. Now, my title has been flowing in terms of the sale deeds that through which I have purchased the land. Now, if the respondents are actually aggrieved by the title in any way, the remedy before them is to approach the civil court. And the exercise, because why the honorable court had said, because 41 does not give any power of review to the circle officer.
You represent whom?
I represent the writ petitioners who had purchased the land.
Who named? Name?
Jahanara Begum.
Okay.
We purchased the land in terms of certain sale deeds, and thereafter our names were inserted in the chitta.
You purchase it from the father of the applicant.
Yes. No, no. I purchased it from one Samad Ali, na?
No. One
I purchased it from the original Patta. Original Pattadar was one Prakriti Chandra Borua, under whom, my lord, there were 3 riots. He is descendant of one of the riots. And the other two riots, they had transferred their share to me. He is claiming that he has an right of inheritance in respect.
They have transferred by way of a sale deed.
Yes, by way of a sale deed. And he is claiming that since he is his predecessor in interest was one of the riot, so he has right of inheritance, and actually he should be regarded as the owner in respect of these lands.
Of the entire land or only the portion of which he was right?
So a portion of it, his claim is perhaps with regard to 5 bigha, 1 kata, 17 lesa.
This is not the total area of land.
No, the originally total area of land was 12 bigha, 1 kata, 14 lesa.
I think we should take up the matter for admission hearing.
Let the government file affidavit.
Let the government, who's for the government? What about the affidavit that we are required to file? It has not come.
5527. We have filed an affidavit.
5527.
But in 3621/2023, their affidavit is still awaited.
Does it cover the earlier writ petition?
No, the question of jurisdiction, my lord, as far as I could understand, my lord, that does not touch.
So, jurisdiction can be decided by the court if no
Yes,
affidavit
but
comes.
at least, my lord, since there is a challenge to the question, I mean, on the point of jurisdiction, my lord, some response should come on this line.
Regarding jurisdiction or whether this honorable court has that jurisdiction or not, that I think not purely a law point. No, not this court, the circle officer.
The only thing they have said in the affidavit that they have not yet given any effect to the order, which is under challenge.
So, but how will the government answer whether the circle officer has jurisdiction or not? On what basis?
So even
Depends
if,
on the record.
yes, that's on the basis of the records and particularly, my lord, the appreciation of the provision of section 41,
Whatever.
regulation 41.
How will the
Yes.
government, that's for the court to appreciate and decide.
Yes, but in the previous round of litigation, my lord, that is in which, my lord, he has filed the application, the observation of the honorable court was very categorical that before the order is passed, before any order is passed, they will have to, the circle officer will have to determine first whether he has jurisdiction under the provision of the regulations or not. That aspect of the matter has remained unanswered by the revenue authorities. That is why, my lord, the affidavit was called for. 17(9) order of your lordships, my lord. The affidavit was called from the revenue department because since this was the specific direction of the honorable court and that direction has not been given any weightage. So that is why the explanation was sought. But otherwise also, my lord, notwithstanding any absence of answer from them, the lordship can always examine whether section 41 permits carrying out such an exercise. Because ultimately the title has flown to me by virtue of some registered sale deeds. And Patta was also issued.
What was the order of that circle officer?
That is, I have shown to your lordship at page 82, yes. And page 82 is silent. Page 82 is silent on the point whether or not he has jurisdiction to do it. That was the direction of the honorable court.
This is challenged in the subsequent writ petition.
Subsequent writ petition.
What did you challenge in the earlier writ petition?
Earlier writ petition, my lord, a report of the Latmandal by which, my lord, the exercise was about to be undertaken. I apprehended that they will do this, my lord. That's why I came and the honorable court passed that order.
How many writ petitions you filed? Two or
Two,
three?
two. And he is seeking vacation of the order passed in the first writ petition.
So pursuant to the first, this order has already been passed.
Yes, this has been passed, but since this has been under challenge, my lord, in the second writ petition also there is an order stay order granted in my favor
But I is filed in which petition?
in the first writ petition.
So
Now-
effectively, that has become redundant now.
But still, my lord, the basis of
No,
force
the
is from that
vacation-
order.
The vacation of the interim order in the first writ petition. Pursuant to that, this order has already been passed,
Some order has been passed, and that is also under stay.
which is also under stay. So we will have to hear the matter. There's no point in vacating the interim order and allowing the matter to remain. You tell us.
Any date, my lord?
I see three writ
Indeed.
petitions. I don't know why.
No, two writ petitions, my lord. One is the IA.
One is the IA.
One is the IA.
IA filed in 3621.
Yes.
Yes, government, you want to file any affidavit in terms of the order? There is a specific order directing you to file an affidavit. Order passed on 23/6/2023.
Lordship may fix it for applicant hearing in the
Heard General Counsel for the parties, this IA has been filed seeking vacation, modification of the order 23/6/2023, passed in IA number passed in WPC 3621 of 2023. The state respondents were directed to file an affidavit to bring on record its stand as to whether the circle officer by deciding on the question of whether the circle officer has the where is that order?
That order is in the IA, my lord, page 14. In the IA, page 14.
No, but where is the direction of the court to the state to file the affidavit?
That is on 17th September 2024. 17th September? 17th September.
By order dated 17/9/2024, passed in the IA number 2048/2024 in WPC 3621 of 2023. The court directed the state to file either in the IA or in the connected writ petition an affidavit of the state that pursuant to the response by the circle of dated 1/9/2023 in case number GMC slash Miss MISC slash 2023/05. The circle officer Gauripur Revenue Circle of the passed the order with effective date WPC 5527/2023. Of the state writ petition, state has already filed their counter affidavit. You're not filing reply.
One reply filed, my lord, in the affidavit filed by the
Against
government.
the affidavit filed by the state.
In the IA, we have filed, but in the writ petition, no reply.
Do you want to file or
Yes,
we close
yes.
the pleading?
Yes, yes.
Yes, what?
I'll file a reply, my lord. Let the affidavit come.
The petitioner, however, craves liberty to file reply the counter affidavit filing. According, this court is of the view that it will serve the purpose of the issues raised if the IA is heard along with the writ petitions. So let the writ petitions be fixed for admission hearing. After 2 weeks, you have already filed. All right, 3 weeks. On a date to be fixed by the registry. The parties are directed to complete their pleadings in the meantime.
Copy.
Your
copy of-
I is pending, will take it up along with the writ petition.
My lord.
And my lord, the interim orders in the writ petition may be
Interim
continued.
orders passed in the writ petition will continue till the next date of next week, which is 12th of December.
Oblige me.
Copy of the affidavit is not served to me.
You serve copy? Respondent. Are you a respondent in the second writ petition?
My lord.
Should have been served with a copy.
Oblige me.
Bless you. May it please your lordship.
Yes.
Lordship, Annexa 3, at page 14, 15, Lordship, kindly. Avnita.
Lordship, in this case, we have been directed to file affidavit, Lordship. I'm praying for some time, Lordship. We have not received the instruction.
Third learned counsel to be Mr. Rick Sharma, the advocate, submits that would like to file an affidavit. Let me release accordingly. Waits for 3 weeks' time. Let the matter be put up, enabling the state to file the affidavit. Matter be listed again for admission.
Look.
Uh,
Lordship, date me.
Huh?
Date, Lordship.
Well, 12th of December.
Obvious.
May I please your lordship?
My lord, this is the railway matter, my lord. Lordship, had waited for the outcome of the.
Yes.
My senior is in court too, lordship. It may be taken up on Friday.
No, you call him, we'll take it up after a while. Who is your senior?
R. David.
His caller will take it up after a while. The majority judge.
Majority judgment. I have a copy of that.
Actually, lordship, we have received the Supreme Court order today itself, so we need some time to go through it.
You go through now. We'll call it up if required at 2 p.m. At 2 p.m.
Lord. Oblige.
But this case, my lord, earlier your lordship had, my lord, rejected during the investigation stage, my lord. That's why this case has been listed before your lordship.
Yes.
Here, my lord. Can I start, my lord, that if the prosecution is not there?
Sorry?
Prosecution side is not available.
Prosecute.
Well, I may start, but the lordship will find the FIR, my lord, at page 1414.
So this was dismissed as not pressed.
Not pressed, my lord, and because charge sheet was late at that point of time. Now the rules in the High Court, my lord, if it comes before any judge, my lord.
Dismissal means dismissal on merit. Anyway. It will come.
Yes. Page 14 is the FIR, my lord.
Yes.
The last part, my lord. During search, the following items were seized from the possession of the alleged person, kept concealed inside the vehicle along with the NDPS substance. Number one, my lord, 7 number of soap cases, each soap case containing 1 polythene packet, brown color, powdery substance, suspected to heroin. Total weight of the suspected heroin is 72.15 grams. And the second is, my lord, 2 brown color packets, each containing 50 numbers of blue color small packets, and each blue small color small packets contains 200 numbers of Yaba tablet. So in total, my lord, heroin, my lord, 72.15 gram. And Yaba tablets, my lord, 20,000 in numbers.
200, no. 20,000.
20,000. Now your lordship will turn to page 20, my lord, 20. That's the inventory, my lord. This is the inventory prepared by the investigating officer, my lord.
Yes.
Your lordship will find in the my lord, in the fourth column, my lord, number 107, 7 numbers of soap cases, each soap containing 1 polythene packet of brown color powdery substance suspected to be heroin. Total weight of the suspected substance is 72.15 gram. Number 1. And the second, my lord, your lordship will see, my lord, 20,000 numbers, including packets. Total weight of Yaba tablet is 2.150 kg, my lord. So far heroin is concerned, my lord, it is a, my lord, in between, my lord. So B. And so far the Yaba tablet is concerned, my lord, it's a commercial, my lord. Now, my lord, the lordship may kindly note, my lord, the petitioner, I'm here for only one petitioner, my lord, Nurchan Ali, my lord. He is the handyman of that car, my lord. Now, lordship may kindly note, my lord, he was arrested on 06/04/23, my lord. 06/04/23, and the charge sheet was laid, my lord, on 5/8/23, that is at page 30, my lord.
35.
Page 30, my lord, it starts, my lord.
Where is his name?
Page 30, my lord. The charge sheet, my lord.
No, where is his name?
His name, my lord. His name, your lordship will find, my lord, in the forwarding report at page 21. (22) is the operative part, my lord.
You're referring it to the charge sheet.
Charge sheet, my lord. Charge sheet is at page 30, my lord. 30.
Yes.
Page 30 is the charge sheet, my lord. Here, my lord, the next page, my lord, page 32, my lord.
Nurchan.
Nurchan, my lord. Page 32, my lord, below your lordship will find, my lord, the number of witnesses, my lord. 1, my lord, it goes to the next page, my lord. There are 8 numbers of witnesses in this case, my lord.
Yes.
Now, I am referring to page 24 for a once, my lord. My lord, this is the order passed by the Judicial Magistrate First Class, Kamrup, my lord. My lord, generally in the NDPS case, my lord, when any contrabands were seized, my lord, the duty of the investigating officer or the seizing officer, my lord, to produce the contraband before the magistrate, and that drawing of sample should be drawn before the magistrate, my lord. But this is the order, my lord, 10/4/23 at page 24, my lord. Seen the prayer of the IO for drawing representative sample for the certification of correctness of inventory and to take photographs during the time of drawing samples, my lord. In regard to the seized suspected heroin, the concerned IO has prayed for certifying the correctness of the inventory, permit taking photographs of the seized article of the inventory in my presence, and to certify such photographs are true. Allow draw of representative samples in my presence and to certify the correctness of the list of samples. The prayer of the IO is allowed in view of section 52A(3) of the NDPS Act, madam. Below your lordship will find those were there, my lord. Now your lordship will turn to page 26 for a one. Same order, my lord. Page 26. Page 26, my lord. Below the table, my lord, your lordship will see, my lord. The said inventory is found to be as per the seizure list of the instant case. Hence, I hereby certify the correctness of the inventory so prepared. The photographs of the seized substance have been taken and the same is produced before me. I have seen the photograph and found it to be correct account of the seized substance drugs. Hence, I have signed the photograph of the seized substance drugs and also certify the said photographs is true photograph of the seized substance drugs. Next paragraph, my lord. As the seized drugs heroin is homogeneous in nature, hence two random samples have been drawn out of the 7 packets weighing 10 gram each and numbered S1 and D1. Now your lordship will see, my lord, 7 numbers of packets have been seized. But the IO in front of the magistrate, my lord, he has made, my lord, only he has drawn 2 samples, my lord. So samples were not drawn from each packet. Number 1, my lord. Secondly, my lord, further in this regard to the Yaba tablet, as number of quantity suspected drugs are huge, 1,000 tablets and the 10,000 tablets and the seized drugs are identical in nature, Yaba tablet. The 50 packets have been divided into lots, each lot containing 10 packets and numbered at L1, L2, L3, L4, and L5. So here also, my lord, there are 50 numbers of packet, but the magistrate has made a lot, my lord, of 5, my lord. But what the mandate of the, my lord, the act says, my lord, it should be drawn from each packet. The next page, my lord, after dividing the same into lots, 2 random samples have been drawn from each lot, which are in blue packets containing 100 tablets each, which is numbered as following, my lord. Now your lordship will come below, my lord, second paragraph, my lord. Let also photocopy of certified inventory and certified photographs be kept with the case record. It is in the case record, my lord. In view of section 52A1 of the NDPS Act, the IO is hereby directed to make necessary prayer for disposal of the seized narcotic drugs and psychotropic substance before the District Drugs Disposal Committee headed by the SP Kamruk within 30 days. This is not necessary, my lord. Now your lordship may, if your lordship may have a loop of 52A of the NDPS Act. Chaudhary.
NDPS.
Yes.
Yes.
Page 45, my lord. Yes, page 43, my lordship will say 52A, my lord. Disposal of seized narcotic drugs and psychotropic substance. The central government may, having regard to the hazardous nature, permanently to have substitution constant of proper storage space or any other relevant considering in respect of any narcotic drugs, psychotropic substance, controlled substance or conveyance by notification in the official gazette, specify such narcotic drugs, psychotropic substance, controlled substance or conveyance or class of narcotic drugs, class of psychotropic substance, class of controlled substance or conveyance, which shall as soon as may be after the seizure be disposed of by such officer in such manner as the government may from time to time determine after following the procedure hereinafter specified. So as per 52A, my lord, the central government is to make a notification in the official gazette, my lord, how this has to be done, my lord. Now your lordship will, in the same book, my lordship may turn to page 259, my lord. Page 259, the lordship will find the rules, my lord. The narcotic drugs and psychotropic substance seizure, storage, sampling, and disposal rules 2022. Lordship have got it, my lord. Number 3, my lord. Seizure and storage of seized material. Number 3, my lord. Classification of seized material. The narcotic drugs, psychotropic substance, and controlled substance seized under the Act shall be classified based on physical properties and result of the drug detection kit, if any, shall be weighed separate. So here, my lord, the IO, my lord, in all police station, my lord, there is a kit, my lord. My lord, it's a color kit, my lord. As your lordship has seen, my lord, in currency note, my lord, they put a powder, my lord. If we touch it, it becomes pinkish in color, my lord. Same thing, there is a kit in every police station. So when the police officer seizes any contraband, he should check with his kit, my lord, by putting a chemical, my lord. So thereafter, he came to a conclusion, it may be heroin or it may be any substance. Thereafter, my lord, now two, my lord, if the narcotic next page, if the narcotic drugs, psychotropic substance, controlled substance are found in package or container, such package and container shall be weighed separately and serially numbered for the purpose of the identification. Next three, my lord, all narcotics, drugs, psychotropic substance and controlled substance found in loose shall be packed in tamper-proof bag or in container which shall be serially numbered and weighed, and the particular of the drug and the date of the seizure, my lord, has to be mentioned on such bag and container, my lord. Now, lordship may turn to rule 10, my lord, drawing the samples. 10.
Yeah.
One sample in duplicate shall be drawn from each pack and container seized. When the package and container seized together are of identical size, weight, bearing identical marking, and the contents of each package give identical result on color test. This is very important, color test, by the drug in identification kit, conclusively indicating that the packages are identical in all respects. The package and container may carefully be bunched in lot of not more than 10 package or containers. For each such lot of package and containers, one sample in duplicate shall be drawn. So in the instant case, my lord, no testing was done by the kit, my lord.
Hmm.
Next, my lord, number
These
3.
These are matters of trial.
Yes, my lord. It is the matter of trial. My lord, now the question is, my lord, whether I'm coming to that, my lord, only for the last, my lord. In case of drawing sample for a particular lot, it shall be ensured that the representative sample in equal quantity is taken from each packet or container of that lot and mixed together to make a composite whole from which the samples are drawn for that lot, my lord. So this is the rule, my lord. The IO has to follow this rule, my lord, as well as the magistrate, my lord. So in the instant case, my lord, I was arrested on 6/4/23, my lord. And the charge sheet was laid, my lord, on, my lord, 5/8/23. And charges were also framed, my lord, on 5/12/23, my lord. So till date, my lord, 1 year, 7 months, around 8 months, my lord, has passed, my lord. Not a single witness has been examined, my lord.
How many witnesses? 8.
There are 8 witnesses. Till that, not a single witness has been examined, my lord. So, my lord, my prayer before your lordship, my lord, on, my lord, 2 points. First of all,
He was arrested on
he was arrested on 6/4/23.
23.
And the charge sheet was filed within time, my lord, that is 5/8/23. And charges were also framed, my lord, on 5/12/23. Last year, my lord, December, my lord.
So what is
Till-
the cause for non-examination?
Yes, long incarceration, my lord, prolonged incarceration, my lord. On that, my lord, I will rely on
Why
that.
the trial is not progressed?
Actually, I need, my lord, some time to go through this order sheet, my lord. That matter.
No,
Some more
I
time.
have gone to the record, LCR, my lord. There's a report of the judge, my lord, why it has not been. First page, my lord. The witness did not turn up, my lord.
You go through it. We'll take it up on Friday.
My lord.
Can it on
My-
Thursday, my lord? Friday,
Thursday. Thursday.
My lord.
Thursday.
You go to the record
My lord.
and tell us why the trial is not permitted
My
in
lord.
spite of more than 1 year.
My lord.
Not a single witness exam.
Yes, yes, my lord. I will go through the, my lord, order sheet. Anything is there.
Not only go through, you make inquiries to find out what is going on.
My lord.
And
In
my
your
lord,
prosecution, you're representing,
My lord.
you're appearing
additional public prosecutor.
No, this is an NDPS matter.
NDPS state, my lord.
By the state, my lord.
My lord, my submission is twofold, my lord. First of all, my lord, they have to comply with the rules, my lord. Because there are two certificates required, my lord, one certificate is not given. So ultimately, trial will vitiate, my lord, if that certificate is not
We'll
there.
examine on Thursday.
Yes, my lord.
On Thursday.
On
point
Thursday.
out.
My lord.
Yes, let the matter be listed on Thursday.
I am obliged.
Permitting the a learned APP,
My lord. K. Boshro, my
K.
lord.
Boshro, to complete his instruction and examine the necessary reports for. Let the matter be listed according to Thursday.
My- Deeply obliged.
Mr. NJ Boshro, for the petition. Mr. Borua, how can you be so elusive?
My lord.
How can you be so elusive? From 10:30 people.
No,
are searching
Mayor,
for
what
you.
happened, my lord? This case copy was not served to me. This might have been served to other council. That is why I was also informed to the NSIDCL also, office also. This and another matter is this, I am defending that was 5098. I informed
No,
them,
right.
they are not similar.
Now they are asking for 2 months' time.
Oh, that is. But lordship, before that.
No, that order is there, page 184.
Similar matter,
No, not similar, 184.
Which
Well,
is-
that order is 184.
petitioner is similar.
In fact,
Same.
no, that was a separate cause of action. 187, my lord.
Yeah.
Itu no জানি। Para 12, my lord, at page 187. This court, however, would observe that although the respondent authorities can very well take over the possession in terms of
No, this is a separate order.
separate order.
This
No,
is-
matlab, here-
This is a.
Subsequent order.
same order.
Subsequent order.
কোনটো?
That to 110.
Subsequent.
1311, that order was passed. Again,
Reasonable time. Reasonable is not 3 days.
it is.
A request has been made to for reasonable time, that too depending upon exigency of Santa. This court feels matter again, it is made clear, has an order restraining from taking over possession.
So this is okay, but 3 days dismantling and moving away is not possible. So they're asking for 2 months' time. If you are agreeable, we close it, fixing 2 months.
And
time.
we'll give an undertaking that
Sure, my lord.
we'll give an undertaking within 2 months, will lord.
That is why this lordship I am placing before lordship discharge similar to both the matters. That is why.
No, my lord, I think my learned friend has not gone through it.
No, because
Earlier,
yes,
here
certainly
we
I am
have-
not.
Here we have challenged the final award as well as the impugn order, this order. In earlier round of litigation, the award was not issued when we filed the case. Secondly, we made a prayer for making an assessment, passing the award. I can
See,
place that earlier
If
petition, my
we-
lord.
If we have to enter into the merit,
Hmm.
then if we are satisfied that some interim order is required, then we'll have to hear the matter at perhaps
Oh,
the interim
or
order.
lordship, my humble submission before lordship. This my learned senior counsel is saying that it is a award is being challenged. If so, if award is being challenged, they have to go to arbitrator under section 3G5. That I am on that also, my lord. As this order was passed by this
Coordinate bench.
coordinate bench, my lord, that is in 5098, fixing the date 1611.
12.
1612. 1612. This matter may be fixed. And till that, your lordship, because my.
Then again, there will be a stay order.
Stay order.
Now, what my lord is saying is, instead of going into the merit,
It's a
we'll
question
close
of
this
60
matter, then within
No.
2 months we'll vacate. I think
because-
that's better
because-
order for them.
No, better order because it would have been first time, because second case has come, that is why, my lord, we have to
heard,
see on.
Mr. K. N. Chaudhary, learned senior counsel, requested by
So,
Mr.
আগৰ prayer এইকেইটা।
Alam C. Borua appearing for the unit respondent number 1,
Respondent number, my lord, I'll appear, one, I'll appear, 5 I'll appear. Then,
you'll appear for 3 also,
yes, my lord, 3.
1, 3 and 5.
3, 1, 3 and 5, my lord.
MS 4 appears for
6 and 7, Lord.
2, 6 and 7. And PWD, who appears for PWD?
Some PWD, my lord.
Mr. P. Gogoi.
Okay.
The quarter number 8. Requisition is directed against this petition is directed putting to challenge the 3 capital G award case. In respect of the petition, in respect of the valuation of the land, measuring 19 kotha, 10 chatak. The second RS number 5, dark number 10. Watch the impugned letter and to set aside the communication dated 12/11/2024 directing the petitioner to vacate the premises within a period of 3 days and a further direction to allow the respondent a period of 3 months time for shifting of their showroom to a alternative site. Third counsel to the senior counsel to the petitioner subject that at this stage, the petitioner is only praising for a reasonable amount of time to shift the showroom to an alternative place which has already been identified and steps are taken. Develop the said site for shifting to that place. So the learned counsel submits that 3 months time is very reasonable for completing the shifting. Better. Mr. C. Borua,
my lord, for a moment. This impugned order which is being
It's by the
challenged,
deputy commissioner.
it is not by me. It is by the Kala, Competent of Land Acquisition. That is page 180 and except 22, my lord. That is by Kala. That is by
they have no instructions in the matter. However, in any event of the matter, since the award has already been passed, their remedy lies under the provisions of National Highway Act. And therefore, since the land has already vested in the National Highway Authority, they are duty bound to vacate the premises. And in any event of the matter, 3 months would be too long a time to permit the petitioners to be granted to the petitioners to shift to the alternative place. But accordingly, we direct the matter to be listed again on 27.
and another matter is 1612, my lord.
Maybe 27, by which date the respondent council will complete their instructions and apprise the
May I please, Lordship? Okay, as per Lordship, have an instruction, as I have instructed them. They told me that demolition may be placed today, Lordship.
what?
Demolition may be placed today, Lordship.
Complete their instruction and so that
how
reasonable
long
time
this-
is granted to the petitioner. In respect of the prayer made for by the petitioner to grant reasonable time, shift the alternate. Stop. This again on 27 of, sorry, 26th of November. Status quo to be maintained by the parties in the next day. It's very clear that to demolish, to undertake demolition of the state property without till the next day.
Deep reflect.
But Lordship, I'm not aware, but as per Bhave's instruction,
We have, and the petitioner council on record will ensure furnishing of adequate
Copy of it.
sufficient copies within the course of the day.
Deep reflect.
Come back with your instructions on 26.
Lordship.
Yes. Education, who's for education count?
Lordship, I'm appearing for education, Lordship.
There was a direction to permitting you to complete your instructions.
Lordship. But they are seeking some time, Lordship. Another 15 days time is required.
In terms of the earlier order dated 16/8/2024, the Planning Council Elementary Education Department was directed to complete the instructions with regard to the particulars reflecting the employment of the petitioners and the affidavit filed, and 3 weeks time was granted. So today, further time is granted. The further time is sought for by the respondent. Complete their instructions. Let the matter be extended after 2 weeks.
2 weeks, Lordship.
2 weeks further time.
Yes, in this case, Lordship, as per direction of your Lordship, on 2/5/24, Lordship, a status report I have already,
No, the last order is there, the 16/8.
yes, Lordship.
16/8 order is there.
Yes, Lordship, that status report is part of the record, Lordship. Then on 2/5/24, Lordship directed me to take up to the status report, Lordship. Ready and wait on a good school.
Is it not placed before the court?
Yes, I have already placed, Lordship, on 2/5, Lordship. 2/5/2024, Lordship. No, no. On 28/5, Lordship, I already. Subsequently, Lordship, I directed the petitioner to file additional affidavit, Lordship.
So therefore, on the additional affidavit, we wanted you to obtain the
Yes,
instruction.
Lordship.
You have.
Yes, Lordship. Yes, Lordship.
To get your instructions, we'll have it down after 2 weeks.
Yes.
List accordingly.
Okay.
Obliged.
My lord, the short point involved is on the failure of the state to factor in the GST factor in their estimate, my lord. Now they cannot, my lord, burden us with the liability. Now, if your lordship would kindly come to page number 175, my lord. The government of India has made the position very clear. Page 175. It's a communication by Government of India in the Ministry of Rural Development. The operative portion is at 177.
Yes.
Please come to D, my lord. In case of all new works to be proposed under PMGSY, the state shall prepare schedule of rate after deducting the taxes subsumed under GST. The detailed project report shall be prepared based on this revised SOR, and the state may add 12% GST to the cost of the work to arrive at overall cost of the work. So the government of India has already issued the direction. Now they are doing, my lord. Now what they did not do earlier was, now please come to my lord, page number 40, page number 103. This is how the earlier clause stands.
No, but this communication is effective from which date?
My lord, actually, my lord,
6.
GST regime came into effect from, my lord, July 2017. Thereafter, this was issued, 2018. And, my lord, government of Assam, now they have corrected. But in the earlier contract agreement, it was not done. Now, if your lordship would kindly come to page 103, the earlier contract clause used to be like this: taxes, 41.1 at page 103. The rates quoted by contractors shall be deemed to be inclusive of sales and other levies, duties, royalties, cess, oil, taxes of central and state government, local bodies and authorities that the contractor will have to pay for the performance of the contract. The employer will perform such duties in regard to deduction of such taxes at source as per applicable law. This was the earlier clause. Now, if your lordship kindly comes to page 183, now pursuant to that government of India direction, now they have changed it at 183.
Yeah.
.1 rates quoted by contractors shall be deemed to be inclusive of service tax. So, well, now they have changed, but earlier they did not do. Now, as a result, what they are doing, now they are trying to burden us. Lordship knows, my lord, it is the recipient of the service who is liable to pay GST under section 9(4). Recipient of service is the state. So now instead of, my lord, state paying it, they are trying to burden us with the liability, which is in law, it is not, payable by us. And the circular issued by the government of India was of 2018, my lord, and the NIT was issued in 2019. So
This page 103 is a part of your agreement, which was issued in 2019.
yes, 19.
So you are laying stress on the highlighting the petition here.
Yes.
That reduction of taxes will be as per applicable in law.
And if your lordship would kindly have the GST Act for a moment, my lord. And page 37, my lord, 34. Somewhere in the middle, contract agreement number CE so and so PMGSY 134 13619.
On 34.
No, page 34, my lord, only 34.
Yes.
Somewhere in the middle, my lord, contract agreement number CE CO so and so PMGSY / 144 dated 13699. And under the relevant statute also, my lord, section 9(4), GST account liability.
Yes, 9(4).
Subsection 4, my lord. Central taxes in respect of supply of taxable goods or services or both by a supplier who is not registered to a registered person shall be paid by such person on reverse charge basis as the recipient, and all provisions of this act shall apply to such recipient as if he is the person liable for paying tax in relation to supply of such goods or services or both.
You are reading from
Subsection 4 of Section 9 of Central Goods and Services Act 2017, Miller. Subsection 4 of Section 9.
this was substitute. I think kindly read again.
Central taxes in respect of supply of taxable goods or services or both by a supplier who is not registered to a registered person shall be paid by.
This was substituted with effect from 1/2/2019.
Oh.
The government may on the recommendation.
I think now it is the government may on the recommendation of the council by notification specify a class of registered person who shall in respect of supply of specified categories of goods or services or both receive from an unregistered supplier, pay tax on reverse charge basis as recipient of supply of such goods or services or both, and all provisions of this act shall apply to such recipient as if he is the person liable for. So, my lord, structure is same, Miller, and the format, little bit of change is there, but the liability to pay tax is upon the recipient of the service.
189.
Yes.
No, we'll put.
Now, if your lordship would kindly come to page 189, Miller. Page 189. Now, pursuant to your lordship's query, they have come up with the same, clarified the position, my lord. Yes, page 189.
Yes.
Para 3. That the deponent by way of an additional affidavit begs to submit that procedure laid down under category D in that letter which I referred is followed in the procedure as enumerated herein. That for all new works to be proposed under PMGSY, the rates are based on SOR rate prepared excluding GST. Including whole.
Yes.
So they admit, my lord, while preparing the schedule of rates, they have not factored in the GST component. So there is a clear admission, my lord.
Yes. But for the existing, what is their stand?
My lord.
For the existing contract?
Yes.
What is their stand?
They have not clarified. That's the affidavit ends there at page 189.
So, if it is on reverse charge,
yes,
then what happens in your case?
No, in any case, my lord.
You have completed the contract.
Yes.
Right. So you had projected the rates.
Yes.
Then
No, my lord, now what they're doing, that they want to deduct from us. But the SOR, that it did not include the GST component. Now, my lord, if for their failure to add to the schedule of rates, now we have been made liable. That is against the statute.
No, but as a contractor, you are also expected to be aware of what is the taxing law.
No, my lord,
which will govern
now,
the cases.
if we go by the existing 41 also, perhaps, my lord, there is a escape route. So lordship would kindly come to page number 103. Employer will perform such duties in regard to deduction of such taxes at source as per applicable law. Applicable law is section 4 and the rules framed there under 9(4).
Is there any specific agreement entered between the parties?
No, this is the agreement. I'm reading from the agreement only. Employer will perform such duties in regard to deduction of such taxes at source as per applicable law.
Yes. They're not relying on any authority.
No.
Proposal.
It's so open and shut in our humble submission, my lord, which will not burden your lordships with any authority.
Here, my lord, we have filed an affidavit in opposition.
You know.
Lordship will see, my lord, running page number 159.
159. Yeah.
Para 4. Where did you? The answering deponent begs to state that the executed value of the bill was so and so, and that since the previous bill amount is rupees so and so as per running bill account. So and so, the division office passed the bill by affecting the all necessary deductions, including 1% GST, 1% as state GST, as per the terms and conditions of the contract. The net value of rupees so and so was paid to the contractor by online payment. In this connection, it is mentioned here that as the petitioner is a registered class 1 contractor in APWP and executed construction work under the construction work under State of Assam. The central GST and state GST at the rate of 1% is to be deducted from the bill. It is as per guidelines provided by the empowered officer. Of summary, no provision for adding of the GST at the rate of 12% have been kept in the contract agreement. The contract agreement is the mutual consent of both the parties, that is empowered officer and the contractor, and signed by both of them. Hence, the claim of the contractor is not sustainable. The claim of the contractor is not sustainable and
is not entered in.
The hands of the respondent number 3 is strictly tied by the various clauses of the contract agreement. No provision has been incorporated regarding adding up GST amount provided in the tender agreement of the petitioner. The GST Act has been introduced in Assam and other parts of the state on 1/7/2017, and provision of the deduction of GST as source was applicable from 1/10/2018 by notification dated so and so. 13/9/2018. The notice inviting tender was plotted on 8/1/19, which is after the enforcement of the GST Act, and being a class 1 contractor.
Why are you reading the affidavit? You tell us your stand.
My lord, our stand is, my lord, so far as the clause 13.2 is concerned, 13.3, that is our, my lord, main ground. Lordship will see, my lord, page 165. This is a part of the contract. Clause 13.3. Page 165. May I read the clause? All duties, taxes, royalties, and other levies payable by the contractor under the contract or for any other cost shall be included in the rates, prices, and total price bid price submitted by the bidder. Our contention is this, my lord. While submitting the, my lord, bid by the petitioner, whatever rate he has quoted, he has included the, my lord, GST in that particular, my lord, bid amount. So now, my lord, after the work is completed, he cannot say that, my lord, that GST part will have to be borne by us separately, irrespective of whatever is the bill amount. Now, my lord, to this effect, my lord, there is not a single statement stating that, my lord, whatever rate the petitioner quoted at the time of submitting his bid in 2019, that GST component was not added in his, my lord, bid price. Because as per his quoted price, my lord, we have accepted it. You will have to make a specific stand that
no, it is the case projected that GST is to be paid by the person receiving the service.
My lord, in subsequent tenders, my lord, the petitioner has brought on record. It has been categorically mentioned that GST components should not be there in the bid amount, my lord.
a different issue.
No, it's
But
it's an important
whether-
issue
whether-
because you have indicated that don't use add that particular GST component. But here is a case, my lord, we have stated as prior to my lord, GST came in, this clause was there. So it was not modified in this particular contract, my lord, or say, my lord, in the tender document. So accordingly, my lord, going by this particular clause, my lord, the petitioner has quoted the rate. Now, where is the statement stating that yes, my lord, that in spite of this particular 13.1, since I know the law, I have not quoted, my lord, the price bid by including GST.
Para 13 second sentence. Para 13 second sentence, there is a specific case.
Page number 11.
Page number 11, second line, Milord. Petitioner states that when the tender was floated, contractors quoted their bids exclusive of GST.
It's a specific statement.
And further, Milord, however, bills were inclusive of other levies, duties, royalties, cess, taxes, which the contractors are liable to pay in the process of execution of the work.
My lord, where is the specific statement, my lord? May I read it again, my lord?
Yes.
Let them complete their part. Yes.
Petitioner states that when tender was floated, contractors quoted their bids exclusive of GST.
Lord, we will see, my lord, how many contractors are here, my lord. One contractor, he has not stated that when I quoted my price in this particular tender, there was no GST. He is in general, he is saying, my lord, contractors, when the tender was floated, contractors quoted there, whom he is representing, my lord. In general, he has made a statement. He will have to make a specific
How
statement.
specific do you want it to be? It is there.
No, it says, my lord, contractors.
Uh,
He will have to make a statement that yes, so far as this particular quoted rate is concerned, pursuant to this particular NIT, whatever he has quoted, and the work was offered to him, the GST component was not there in that particular, my lord, bid amount. Whatever he has quoted. In general, he is saying, my lord. Because in the affidavit, we have made the categorical scan. What is the reply to that, my lord?
Where is your state? Affidavit filed by
Well, that's how I read out, my lord.
respondent 2.
Yes. That part also will find in page 162.
Eleven, in clear cuts. 11.
Where is that? 162.
Yes, sir.
Which paragraph?
Para 6. 162.
Is it required to be included?
My lord, our apprehension is this, my lord. In fact, I believe that, my lord, he has quoted the rate by including GST, because in the subsequent tenders, even they have annexed some tenders, my lord. We have categorically stated that, my lord, while quoting the rate, my lord, the GST component should not be added to the bid amount. Subsequent tenders, we have clarified. So every contractor does that, my lord. They are aware. But in this particular NIT, the clause is very clear. It's like pre, my lord, GST era. So at that point of time, my lord, that was included. So that's why we have the apprehension that, my lord, he has added it.
Would not have been included because on the
If
date,
not, will be something difficult, my lord, to ascertain, my lord, without a specific statement from the petitioner. That this particular NIT, I quoted this particular rate, and in that particular rate, the GST component is not there. Where is that statement, my lord? One line, my lord, referring to his own rate, that GST component is not there in this particular. Otherwise, he will get a double benefit, my lord. We will pay the GST, he will.
is it all you want? A statement from him on the ground that he has not quoted the rate to decide on this?
This seems to be the only case which has come up before the honorable court on this particular point. Others have accepted whatever we have given. And in the subsequent tenders, when there is a specific clause in the tender itself that don't add the GST component, they have followed, my lord. After all, we are bound by the, my lord, contract agreement.
No, even the contract agreement says it is applicable law. Contract was issued in 2019.
So how it can be this honorable court can, my lord, come to the finding that whatever rate he has quoted, let him show the breakup then, my lord.
You get it on record then.
Yes, let him show the
If it is
breakup
the
that this
issue
is
of
the
the-
component.
No, if your lordship wants that, we can bring on record.
No, we don't
Kindly
want
allow me to place two paragraphs, my
We
lord.
don't want it.
Yes.
Their grievance is that they suspect that you have included because there is no statement
After
saying that
counting
it
money,
is
my lord.
included.
No, we have stated. Anyway, that's what I'm saying, my lord. Para 11 to
We will
14.
examine, my lord. Without the breakup, it will be difficult for
No.
us to examine.
No.
We are the
Breakup
experts.
or whatever.
No, my lord will kindly permit me to read two paragraphs, my lord.
Para?
Para, page 10, para 11. That the petitioner states that instead of adding GST to the bill amount, authorities have deducted CGST and SGST from the running bill of the petitioner at the rate of 2%. In this way, authorities have deducted so and so. That being agreed, the petitioner had submitted a representation before the chief engineer stating prejudice suffered by the petitioner in respect of non-payment of GST to the running bill paid to the petitioner in the matter of above contract. However, the petitioner has received no response. My lord, para 13, let me read from the middle. Therefore, when the authorities prepared the bill on the basis of the rates as per BOQ, the petitioner of the petitioner that was exclusive of GST. As per the provisions of Central Goods and Service Tax Act and Assam Goods and Service Tax Act 2017, GST has to be paid by the government, who is the last recipient of the service. However, respondents have not added GST to the bill illegally so as to enable the petitioner to deposit the same to the GST authorities. Para 14 is also important, my lord. Petitioner states that while issuing the NIT, the authorities did not mention anything about payment of GST. And there being no stipulation, contrary or in deviation of the general law, the burden of payment of GST has to be considered in terms of GST Act and the rules, which mandates that GST has to be paid by the recipient of the services of goods, that is by the department.
They don't deny the position in law.
Yes.
It is clear.
They want to say that it is not clear from the pleadings or records available whether GST is included or not.
Page 21, Lord.
The petition.
This is the thing BOQ.
But
If GST has to be
Mr.
given.
Goi, the rates are available in your office.
Yes.
Page 21.
Page 21, my lord.
No, unless the breakup is given, my lord.
Breakup is not given in that.
Now, please come to page 21, my lord. BOQ, item rates. There is no column. What more is required, my lord? Kindly see quantity, unit, estimated rate, rate in figures, total amount. Sir, 112 টাকা বলে।
If I am liable to pay, I have to pay 18. Now, 112 হলে Now what I done, he will pay me 100 rupees. So 12 rupees will be paid by them. That is the GST.
My lord, if we go by their Government of India circular, the position which should emerge is if a particular item rate is say 100, my lord, then the assurance itself should have made it 112
When we raise the bill.
when we raise the bill. Now, my lord, what will happen? I'll do a work of 100, I will get only 80. I should have got 100. Where they should have added 12. Double taxation on the reverse side. There is nothing, there is no question of we gaining from this. Where is the column for GST?
We have not taken money.
My lord, in paragraph 11 to 14, there are specific averments, my lord, that our rates were exclusive of GST.
Lord, we will see page 29 for a moment, madam. The final amount quoted by the petitioner in the BOQ. It is 171016354.59. Now, Lordship will see the next page, page 30. This is the letter of acceptance of the rate, my lord, of the petitioner. Lordship will see the amount 17, 24, 37, 355. And the rate is only, my lord, as per BOQ is only 17, 10. It is 34 years. Another 24 lakhs have been added. So
Yes.
later, if at all,
It
my
is
lord,
24.
yes, 24.
No, no, you say you don't know. Now you know. It seems you know also. Just now you said there is no clarity. If there is clarity, then you should have said at the very beginning.
So let them place the breakup. Why they are saying on, my lord? Let them.
No,
Let them-
Malad,
There is a breakup.
12% of 17 crore would be much more.
This is the breakup in BOQ.
BOQ.
BOQ is the breakup.
No, my lord,
Only
the
the
beat amount is different. BOQ is only item wise, my lord.
item wise.
Yes.
Yes.
The beat amount will be different, my lord.
It's available in your record.
Lordship, that, yes, my lord, that will.
Why do you want them to file additional documents with the court? It's available in your record.
Then, my lord, Lordship will give me 7 days time. I will place that, my lord. If it is there, it is there. We are not trying to, my lord, gain something from the petitioner additionally.
The whole purpose of
Ultimately-
giving you opportunity after opportunity and filing affidavit is to give us that final figure whether it is there or not.
Oh, that's a clear statement. It's not there.
You find out from the record.
Lordship.
Tell us if it is there. You sort out this issue because this is
No, I understand. Otherwise, my lord, it's about factual part only, my lord. Law is well settled. Everybody knows that, my lord, regarding GST part.
when can you get it?
And my lord, next week, Thursday, my lord, if available, my lord.
27.
Yes, sir.
Yes.
27.
Huh?
Heard Learned Counsel Party
What is
after
that?
proceeding to hear the matter. Something like the question as to whether the amount, bid amount quoted by the petitioner, the tender submitted, was inclusive of GST, as was prevalent on that particular period of time, is not discernible from the, is required to be decided, is required for the purposes of deciding the question as to whether the deductions ought to be made with respect to the petition is as per law. So, under such circumstances, it would be necessary to examine the particular, the details of the bid submitted by the petitioner before the applier. So the reports being available with the respondent PWD, is it?
Yes, PWD.
PWD department, Standing Counsel, Mr. T. Gogoi, submits that he would like to complete his instructions thereon and revert back to the court on the next day. So, accordingly, he has agreed to, by all counsels, the matter be listed on 27th of November.
Deep.
Please, court.
Take that. Right.
Well, in this
The
case, the
first copy, second copy,
my learned friend has also completed the arguments. In fact, only you also wanted only last order you also may say.
They have not completed the argument. On that day, Lordship has only heard about the facts and all that. Since
Then
the
you can
senior
argue.
counsel- No, I have not
No.
completed.
No, you can argue. I was given the impression that you are completed.
No.
And you can complete.
But which matter are you arguing? Any particular writ
My
petition?
lord, 5342, there we have filed our affidavit. That will be,
534.
yes, ma'am.
5.
अभी कुछ लोग फैक्ट्री खोल दी
Okay, order.
Yes.
And which matter is did the petitioner argue?
Well, this is 5340.
5340.
I think the common order, no?
5340.
Order.
এগুলো পুরোটা হবে।
The assessment year was below. We can round it.
Yes. There was some test report.
Yes, ma'am. In
Quite-
fact, I sought for them about the test report. They have furnished me the same document that has been annexed to the
In
petition.
fact, the department is inquiring from us, there was a report. And
Same report,
and
madam.
I may tell you also, my lord, in fact, it was not sent for the test report.
Though, my lord, yeah.
That was information that samples were taken and thereafter they expired, the time limit, and they have not sent for the test. In
That-
fact, we received a telephone call that if it is available with us, we may give. You know,
This was sent to the food laboratory.
That part, my lord, though they have said that, my lord, they will send it, nothing came up, my lord. So far as my instruction is concerned, my lord, it is the same document which has been annexed to the indirect petition.
हमारे
I have given them,
All right.
yes. This is the document, my lord.
And it's in the petition.
Same thing, madam. Other-
This was sent by us, my lord.
Where was it reflected in the order? Where is it reflected in the order?
My lord?
So-called, no?
Yes, yes. Huh? Just okay.
Page 78, is it?
But it was there in the show code.
Page 78
Yes.
in this writ petition, which is
My lord, page 79. Whereas in case of so and so, the contaminated water has not been used, report of analysis of food samples attached as annexure 2,
Annexure 1 and 2.
1 and 2.
This is not available.
This, my lord, whatever when I communicated, my lord, this is the document they have furnished and I have verified, my lord, it is the same document as, my lord, annexed in the writ petition.
No, which is page number?
Page 84 of the.
Huh? No, okay.
80,
78.
So-called.
Which is that document?
My lord, that document is, my lord, in the, it starts from, so far as, my lord, WPC, my lord, 5342, it starts from, my lord, page 46. And, my lord, 46 to 63.
These are not, my lord, the report on the sample conducted by the state.
In fact, my lord, it seems, my lord, this particular copy has been xeroxed because 46 page appears in my copy also. In my,
Which one?
40?
Page 46, annexure 1.
46 reflects this
5342 is a level, my lord.
level.
Then, yes, the level, then there are lots, you will find the reports at page 57 onward. And 56 is the covering letter.
These are tests done by the petitioner himself.
My lord, you'll also see page 56. The report was sent to us.
56 is the covering letter. It has been sent to the petitioner by the food analyst in the government of Assam, Bamni Meta, 2021.
We got it conducted, no?
Yeah.
But my lord, at page 84, you'll also may note it, my lord.
Definitely all of these, wait, you can both in the multiple.
Okay, both the main point that goes.
all of that. And if the learned senior, my lord, refreshes his honorable code about the main stand, then, my lord, I will give a short reply and I will rely upon 2 or 3, my lord, of judgment.
Yeah, compilation.
Just paper 2. Yeah.
Permission.
While he refreshes, you can refresh your map.
My lord, yes. Madam, actually, my lord, when on the day when the learned senior made the submission, my lord, I was in Lexia under code. So I took, my lord, follow.
His magnanimity that you have requested him and he has agreed to.
My lord, yeah, humble request.
My lord, I always, my lord, with his request, we cannot, my lord. After all, this is a request by the state. My lord, if your lordship permit me, my lord, I prepared a small written submission that I may provide so that the headwise, my lord, it is available.
Just 1 minute, we wanted to inquire from Mr. Gogoi, what happened to the orders passed in those matters regarding revenue board matters? Which were listed
Yes,
today?
my lord, they've been now posted in sometimes in 3rd of December.
Not disposed of.
Not disposed of.
Certificate.
Good one. 71. Basically, on the maintainability point, my lord, the honorable court want to hear from the petitioner in the case.
One of the main points which I submitted for lordship. You also can see page 17.
17. Yes.
Also, may see bold, my lord. The subject products are fruit juice based drinks classifiable under tariff item number so and so of schedule 2 of the CGST rate notification. My lord, our submission on the basis of the various judgments of the Supreme Court and the other courts, my lord, was that these products were fruit-based drink, and the authorities have said since carbonated water was used, and as such, it cannot be said to be fruit-based use. We are also kindly, my lord, see at page 23. The second paragraph, you know. We submitted that the distinction drawn above between fruit pulp or fruit-based drinks and mere flavored beverages is evident from the scheme of chapter heading number so and so. If this distinction is ignored, it would render the specific tariff item number so and so redundant and obtuse. Although subheading 2202 of 99.99 is provided as a restitutory entry, it has to be examined in the broader scheme of the heading 2202. If tariff item number 22021090 is treated to include an apple juice based drink, orange juice based drinks, or lemon juice based drinks, it would mean that any fruit juice based drinks would be susceptible to the classification under the tariff item number 22021090 as flavored water, irrespective of the composition, nature, and common understanding of the market regarding the nature of the product. This is so because in a broader sense, juice or essence is a flavoring agent, and any beverage based on the fruit juice would be classifiable as flavored juice water. However, this is evidently not the intention of the scheme of the classification under chapter 2202 of the Custom Tariff Act 1975, which provides separate entry on so and so. Thereafter, my lord, I have referred to the decision of the tribunal which was upheld by the Supreme Court, my lord. You see find in the page 24, the last paragraph, my lord. The above understanding of the petitioner is bolstered by the several decisions rendered in the context tariff item number 22029020 under the erstwhile Central Excise Tariff Act, which were parametric to the tariff scheme under the Customs Tariff Act
reliance is placed on the tribunal's decision in the case of so-and-so, wherein the issue involved was regarding classification of the product apple fizz. Revenue wanted to classify it under fruit item number 22021010 because it was accredited. The respondents has classified the item under 2202909020 as a fruit juice drink because the product contained 23% apple juice. The SSC relied upon the prevention of so-and-so to submit that the fruit beverages or fruit juice must contain a soluble solids not less than 10%, where the product contained 13.70% so-and-so solid. Rejecting the contents of the department, the tribunal held that the product was classifiable under tariff item number 22029020. Now, there also may skip over, Milord. Page 26. The above decision of the Honorable Tribunal was affirmed by the Supreme Court by dismissing the civil appeal filed by the department as reported in so-and-so. Similarly, the Honorable Supreme Court in the case of so-and-so held that apple fizz containing more than 10% fruit juice, the 12.7% was a fruit-based drink in terms of the provisions of the so-and-so Act. Therefore, the decision of the Honorable Supreme Court in the case of so-and-so is highly applicable to the present factual situation so-and-so. Thereafter, given below other decisions also on this aspect of the matter. In support of the contention below that this is a fruit-based drink.
Yeah.
Thereafter, below at page 38. I've submitted below the present proceedings are violative of the judicial discipline in as much as, my lord, the various decisions of the High Court and the Apex Court were placed before the authorities. But they same were not taken into consideration and the order was passed.
Why were they not taken into consideration?
Because they have said
Distinguishing
that,
on fact.
that this is a Central Excise Act decision, the Customs Act. But you also have to see that the entries were the same. We have to see that what is the fruit based. It doesn't change with the middle of the act. The item will be on the passage of particular entry. Now we'll also at page 40. I have explained below that tariff heading number 220210 will apply only to those beverages which were prepared with flavors, not fruit based, Milord. At page 46, Milord. I will have said below the food safety and standards food products and food electrical regulations can be relied upon for the purpose of determining the correct classification of the subject products. Because the authority said that no, this cannot be taken into consideration for the purpose of classification of an item. And in support of that, Milord, I've given the various decisions also to submit that this can be relied upon. I'm not, Milord, making full arguments only and give refreshing, Milord. Page 51, Milord. As per the general rules for interpretation, a specific entry to prevail over the general entry. Thus, the products in question are classifiable under tariff item number 22029020 HNSN. Explanatory notes are not to be applicable to the present case. We have submitted below when the specific entry is there, then the general entry cannot be made applicable. At page 54, Milord, we have referred to the common parlance test. That in the common parlance, how it is, Milord, known in the trade and the persons who deal with it. And we submitted, Milord, this in the common parlance also it is treated to be fruit based. And thereby, it cannot be classified other than the fruit-based drinks. At page 59, my lord, we have referred to that it is a burden of the department to prove the classification of the subject items. And the said burden has not been discharged by the department. Simply saying that this will not fall in this entry is not sufficient. And I've submitted the various provisions of the decisions of the courts in this regard. On page 63, my lord, we have submitted, my lord, the provisions of section 74 of the Act are not invocable in the present case in the case of any fraud or willful suppression. We have submitted, my lord, all these facts were known to the department, and thereby there was no case of any suppression of any fact, and there, in that view of the matter, my lord, section 74 cannot be invoked for the purpose in the present case. At page 66, I refer to the penalty. The penalty is not impossible. And the most important one, at page 71, my lord, notification number so-and-so, rated so-and-so, and notification number so-and-so, compensation set rate so-and-so operates prospectively. My lord, from this date, when the notification was issued, the carbonated drinks, fruit drinks were brought, rates was enhanced, and this was prospective, not given a retrospective effect. And when the rates were increased from a particular date, then it cannot be said that that rate will be applicable retrospectively. In support of that, they have said that since the notification was issued after the issuance of so-called notice, and as such, this will not be applicable. How the so-called notice, whether issued or not issued, when the notification has been issued for changing the rates from a particular date, how it can be made applicable in respect of the earlier transactions. These are the my submission. I've given all
The notification was issued after the Choco's note.
my lord,
After Choco.
by the government of India.
This is after the order has been passed by the NSD company.
No.
Prior
to passing of the order.
Right. Is there any reference of this notification to in the order?
In the commissioner's order, he has referred to, my lord.
Page number. Five 340, is it?
My lord. No, just I will find out.
May I submit one thing? After getting this compilation, giving the headings and all, if Lordship give me 1 day's time and at least I can respond to every point by tomorrow. Man. Tomorrow also Lordship fixes it. Otherwise, my lord, regarding this notification, my lord, Lordship will see the assessment years, my lord. They are of prior to, my lord, this particular notification of 21. And their own admission, then, my lord, this particular notification will be prospective.
Increasing the rate.
But, my lord, main contention, if your Lordship see that compilation at page
Against,
18.
against the order of the Joint Commissioner, was any appeal filed?
Yes, sir.
No appeal was
No.
filed.
On the GST, against the revision order,
No, you're challenging this order at 144, isn't it?
my lord.
Yes.
Page number 144.
One, well, I am challenging the order passed by the Joint Commissioner, page 284.
Yes. Joint Commissioner.
You're in which writ petition?
My lord, this is the
40.
First one.
340.
Ah,
Last topic.
yes, 284.
My lord.
So is there any reference here that
To my knowledge, no. I don't say it. No. That part was. In fact, my lord, that particular point was not taken by the petitioner. India, my lord, replied. Notification.
Yes, no, me.
No, not there.
all right? We'll continue with that. Let him have some opportunity to address the court.
Only these points, my lord. Even tomorrow I can, my lord, because I otherwise, my lord, some points I have, my lord, but composite way.
You address the court,
Yes, yes. What?
whatever you want to address,
My lord.
not on this point or that.
Yes, yes.
Whatever you want to address,
You will have to, yes.
that goes your right.
So the issue is, my lord, whether it will come under this, my lord, entry number 2202-1090 or, my lord, 2202-9920. That is the whole thing, my lord. Whether, my lord, the fruit juice based particular products of the petitioner are fruit juice based drink, or, my lord, it comes under the heading others. With, my lord, this carbonated water and all, my lord, giving sweetener and all, my lord, the flavor of the juice is given.
Yes, Dr. Saraf.
Major Lordship.
Heard. Saraf. Saraf. Sitting by forward. People. Also heard from the quick. Responded. Petitioner has concluded his argument. You have concluded with a right to reserve, with a right to reply. Reserving his right to reply. Respect. The target has been made by the respondent.
I think it is better that on Thursday, because tomorrow is the motion day.
Yes.
The matter may not reach
Keep
out.
it on Thursday.
Look at the top of the list, my lord, it can come, my lord.
Thursday, some matters in division, my lord.
Let it be tomorrow, I have no problem for it.
But tomorrow may
Or
be
on
difficult.
Tuesday, my lord, if not inconvenient, my lord, if the bench is available on Tuesday. Thursday, Friday, some matters were already fixed.
Tuesday, I'm not there, I'm Calcutta.
Monday, Monday.
Monday, 9, Monday, go here. Let it be tomorrow at Thursday at 2 p.m. The division bench never sits up to 2 p.m.
26th, you are not available.
My lord,
And 28th also,
28 I'm there.
you're there. Leave it on 28th.
But my learned train may complete on that day. my lord.
Yes, yes, I will,
Pending
sir.
for a long time.
28th. For the hearing. Completing. But the hearing of the respondent. It's recording. It would have-
I'm obliged.
Obliged.
Thank you.
This writ petition is against the order passed by the Board of Revenue, by which the ownership right granted in favor of me was cancelled, holding that I was not in possession of the land as required under the Act. The fact of the case is that my father was a Raiti Khatiyandar since the year 1972 on a land measuring 2 bigha 11 acres. So after my father passed away, we have been in possession of the land. So accordingly, we applied for ownership right under section rule 23(1) of the Assam TNC Act 1971. So in the meantime, they raised an objection and a report was called for from the ADC. The report was submitted saying that nobody else is in possession of the land except the main patadar. So we filed an objection against that report. Second report was called for. As per the second report, the circle officer has clarified that we have been in possession of the land. On that basis, the settlement officer granted ownership right in favor of us. Your lordship will find the report at page 23 of my writ petition.
There is no counter affidavit filed. There's no counter affidavit
No,
filed.
I think this is based on records, my lord. All the documents
Not
are
necessary.
not, if your lordship, I prepared a written argument, I'll submit that.
The report your lordship will find at page 23. It says, with reference to the subject cited above.
Just one. Yes.
With reference to the subject cited above, it is to inform you that as per the application filed by Sri Dhaniram Kutia, he is the writ petitioner.
You're reading from?
Page 23, madam. Annexure E.
Yeah.
Very good. With reference to the subject cited above, it is to inform you that as per the application filed by Sri Dhaniram Kutia, his father was possessing the suit land situated at Jorhat town of 3, number Moja, block number 14, covered by PP number 9 of Dag number 20, measuring an area of 6 bigha 4 kata 6 acre, as a Raiti Khatiyan number 59. The aforesaid Khatiyan was obtained from previous patadar Muhammad Abedullah Ukil, son of Noor, whose name was in the records when the Khatiyan was obtained, which has come to light as per the investigation of the Latmonda. During the course of the time, the aforesaid land was sold jointly to Sri Akon Kalita, Sri Savitri Kolita, Sri Moni Kolita, and in the year 1974-75, as per the order dated 25/8/75, in the mutation case number 139, their names were mutated by virtue of their purchase. On the other hand, the class of the land of the aforesaid Dag has been converted to a residential class as per the order passed by the Deputy Commissioner in so-and-so. Therefore, it is not known as to how the class of the land under possession of Dhaniram Kutia as a Raiti Khatiyan holder has been changed, and whether the Raiti Khatiyandar holder has denounced their possession over the land. Previously, during the time of spot verification, the applicant could not show his possession over the plot of land. Thereafter, again on 29/6/2015, as per the order dated 24/6/2015, passed in JEC number so-and-so, when the spot was visited, the investigation, a land measuring 4 kata 5 ledges of the aforesaid Dag was found to be under the possession of Raiti Khatian holder along with the Pakka boundary works. Well, this was the report submitted by the circle officer. Now, if I may take your lordship to the finding recorded by the board, the lordship will find at page 60.
Yes.
We may start from page 61, the fact of the case in brief. The fact of the case in brief is that the appellant is the owner, inheritant, and is in possession of a land measuring 2 acres 6 acres covered by Dag number 9224, old so-and-so, PP number so-and-so, under block number so-and-so, Jorhat town, number 3, Moja. The appellant proposed to sell a piece of land measuring 4 kata to one Srimati Manjula Datta and obtained permission from Jorhat Deputy Commissioner under memo number so-and-so. The respondent Dhaniram Chutia on so-and-so sent an application before the Deputy Commissioner Jorhat claiming periodic pata for a land measuring 1 viga of Dag number 9722 on the ground that the respondent's father was a Khatian holder of Khatian number 53. On 28/2/2014, the respondent filed objection before the DC Jorhat against the sale of the land on the ground that he is an occupancy tenant and a Khatian the holder since his father's name and is farming the land since 1972 and prayed for not to allow sale permission for aforesaid plot of land. The learned additional Deputy Commissioner Jorhat, after hearing both the parties, was pleased to grant ownership right of the land measuring 4 katas 5 acres under Dag number so-and-so, covered by so-and-so so-and-so, to the respondent Sri Dharinam Chutia. Being agreed by the order of the learned additional Deputy Commissioner, the appellant filed the instant appeal. I have heard the learned advocate for the appellant, but could not hear the learned advocate for the respondent since he was absent for several days. The respondents have, however, filed written objection on the appeal memo. The argument of the appellant mainly is that Khatian produced by the respondent is only a draft Khatian, not a final Khatian, which did not bestow the rights of an occupancy tenant to the respondent. Further, the class of the disputed land is already changed to residential class and is no longer an agricultural land, as the respondent has not performed any agricultural activity over this land, nor they have any position. They have not paid rent to the pattadar also. I have carefully gone through the records and other relevant documents and also examined the report of the circle officer. The issue here is whether the copy of Khatian number so-and-so furnished by the respondent can be considered as final record of right, and if so, whether it is still relevant in relation to the instant case. Further, whether the order of the learned additional Deputy Commissioner while granting ownership right to the respondent is bad in law and whether he has considered all factors before issuing the impugn order. On perusal of the record, it appears that the respondent's father was a Khatiandar under the Pattadar Abdul Ukil for an area of 2 vigas 11 acres for a period of 2 years only. The Khatiandar claimed to have obtained the rights of occupancy tenant subsequently. I have gone through the certified copy of the deed submitted by the present appellant, according to which the entire land was purchased by the appellant's father and other member of his family by deed number so-and-so. Subsequently, the portion of this land is sold and resold many times. There is no clear demarcation on which part of this land, measuring 6 bighas 4 kata 6 acres, the Khatiandar respondent interest of 2 kata rest. Further, the land is under a municipal area, not an agricultural land, and status of the land class is also changed from agricultural to residential class. From the report of the circle officer in Gowra, it is clear the respondent has not personally or through any sub-tenant has done any agricultural activity on the disputed land, nor the respondent could establish his possession over the land. The respondent did not produce a copy of the Khatian under Form 19, which is a draft Khatian, but could not establish the final record of it. This finding that the respondent could not establish his possession over the land is, in my humble submission, is perverse, because there is a report submitted by the circle officer mentioning clearly that I have been in possession of the land. And it is also mentioned in the report just now I have read, page 23, that in the presence, when the appellants, writ petitioners are in possession of the land, it is not known as to how the class of the land has been changed. Even assuming for the timing that the class of the land has been changed, but being a tenant, there are some procedures laid down on the act. If I have to be evicted, there is a procedure laid down. If the rent is not paid, but they have not taken any plea, they have not filed any suit or any case for my eviction from the suit land. In that situation, whether the finding of the learned member of the board that I have not been in possession, or I have not been able to prove that I have been in possession of the suit land, is, in my humble submission, is perverse and contrary to the report submitted by the circle officer at page 23. And so far as my ownership right is concerned, the ownership right flows from section rule 23, is acquisition of ownership rights and intermediary rights by the tenants. I have been in possession through my father since more than 3 years, so I have applied for ownership right. On the basis of my application, the settlement officer, ADC, granted me the ownership right, and in view of that, I have submitted 50 times of the amount of premium to the office. And in view of that, my name has been recorded in the Jamabandi. So the finding that the class of the land has been changed, for changing the class of the land, since I have been in possession, I should have been put under notice that this is the land, no agriculture.
But who changed it? Did you challenge that?
No, there is no order. There is no order, no notice, nothing. It is for the first time the board and a member of the board came to a finding that the class of the land has been changed. How it was changed, when it was changed, what was the procedure applied to change the land, whether I was put under notice or not, nothing has been recorded. And the clear finding that I have not been in possession is contrary to the report submitted by the circle officer.
Where is the report?
A report just now I have read page 23. The relevant portion your lordship will find at page 24. It starts with thereafter again on 29/6/2015 as per the order dated 24/6/15 passed in JC. When the spot was visited for investigation, a land measuring 4 kata 5 letters of aforesaid dug was found to be under the possession of the Raiti Khatian holder along with the Pakka boundary walls. But this report was not considered when the finding was recorded. And in the previous page, at page 23, it is also
This land that you claim to be in possession is agricultural land.
agricultural land.
Is it bounded by a boundary wall?
It is bounded by, well, the report says it is bounded by boundary walls now.
Forget the report.
Yes.
You are in possession, you know whether it is bounded by boundary wall.
Now it is bounded by boundary wall.
Not now. On the date when the verification was made.
Yes.
If it is agricultural land, there any need to bound it by boundary wall?
Part of the area has been converted to municipality.
Okay, we'll continue in the second half. Continue.
Lordship is keep it as a partner, my lord.
Yes, pardon you. Yes, where is the council for railways? This is now settled.
Lordship,
This is settled now.
Lordship.
What else is to be done?
Lordship, it may be taken on Friday, Lordship. It is a very voluminous Lordship judgment and some dissenting.
Only you read paragraph operative part, conclusion of the majority.
Conclusion part of that.
You read it, all right. Friday.
Friday.
Friday is good for you.
Friday will be, my lord, 22nd, my lord. I apologize when I out of station, my lord. Can it be on 25th, 26th? Monday, Wednesday, the last week, my.
26.
Lordship.
A joint request matter be listed on 26th of November.
Can it be taken up after 2 weeks?
Hmm?
Can it be taken up after 2 weeks?
The request of learned counsel for the hearing for the petitioner.
Petitioner.
Matter stands before to be listed after 2 weeks.
Oblige your lord.